Hi, welcome back. Let's talk about what happens after you've decided that there isn't going to be a settlement and you put your carrier on notice. So now you're going to have to respond to the lawsuit. You can either make a motion or you can file your answer. What does it mean, make a motion? A motion basically says, Judge, let's not get into this for one of numerous possible reasons. One is, even if everything they claim in the lawsuit were true, they wouldn't have a legal claim. That can be for a lot of different reasons. Either the law isn't what they say it is, they're interpreting the contract in a way that you, judge, can look at and see it doesn't make any sense. They don't have the rights that they claim to have. We want to go into that level of detail here, at least not now. But that's a motion to dismiss for failure to state a claim. And again, these motions are pretty much the same in both federal and state court. But there are lots of other reasons why you might not have to answer a lawsuit. The court might not have jurisdiction over you. We talked about that a couple of lessons ago. The court might not have jurisdiction over this kind of claim. For example, if it's a federal court and someone sues you for hit and run and you both live in Omaha, Nebraska, federal court has nothing to say about that. It's not an option for you. You're not citizens of diverse states making claims for over $75,000, which is what diversity jurisdiction would provide. We discussed that a few lessons ago. And there's no federal claim. So there can be a subject matter jurisdiction issue. There might also be, and this is a very big deal, sometimes an expensive one, there might be an arbitration clause. You might have agreed when you entered into the relationship, assuming that it's a pre-existing relationship with some kind of contract, and a contract can include user agreements for software, terms of service for websites, retainer agreements with law firms or other professionals, or any kind of other contracts. These may require you to go to arbitration and to pay half of the cost of arbitration. That was probably put in there, if you're the smaller business, for the precise reason of making you pay for something that you can't afford and to make it much less affordable for you to proceed with your claim. Courts will enforce this in almost all circumstances, as long as they're satisfied that you had the opportunity to not agree to it. That doesn't mean that you wouldn't have gotten the car or the brokerage services or the legal services or the operation or whatever it is, unless you agreed to the arbitration clause. That's a choice that you make. That's the deal that you make. But what they might say is you weren't really given full information as a consumer or an unsophisticated businessman. And what rights do you surrender in arbitration? Biggest right of all, besides the right to free services in the United States or state courthouse of your choice, or someone else's choice, is the right to appeal. For all practical purposes, there's no right to appeal from an arbitration. When I say all practical purposes, what kind of exceptions are there? Undisclosed conflict, fraud, corruption. You catch them giving the arbitrator a bribe, stuff that really doesn't happen. So if you get a stinker for an arbitrator, just like if you get a stinker for a judge, you're at that arbitrator's mercy. The difference is that with a judge, you can appeal. For example, in the Southern District of New York, it's pretty much meaningless because the Second Circuit Court of Appeals doesn't really hardly care about most cases. That's just a well-known fact. Certainly civil cases and certainly not for little people. That's just the way it is. Because Congress made it the law of the land that if people do agree to it, it is enforceable. And why did Congress do that? Well, when it did this, it was in the middle of the 20th century, and the thinking was, let's allow people to work out their disputes privately. You see, one of the good things from many points of view, not all, but from many, about arbitration is that there is no presumptive openness. In fact, most arbitration proceedings and awards, the outcome of an arbitration is called an award, are private. That's worth money to a lot of people. Also, because there's no right of appeal, it's cheaper. And in fact, there's a lot less procedure sometimes not so much less, but there should be less. There's less discovery and there's less procedure. And the irony is it would be even more expensive if the system that had been envisioned were actually still in place. What's that system? Usually an arbitration panel was understood to be a panel of three arbitrators. Each side would choose one, and then they would agree on a third arbitrator. So that's what you were giving up in return for the loss of your appeal right. These three wise men, and they inevitably would be men, would come to a fair conclusion of, well, what happened was it just became as expensive as arbitration is now because you're paying for very experienced people with the ability to make legal decisions or decisions having roots in legal relationships that implicate sophisticated and high dollar value disputes. You need somebody experienced and to some extent talented. Paying for three people like that is, except for the very, very biggest disputes, financially. So what we have now is you're stuck in arbitration with one judge or one arbitrator. Not much of a difference. And in fact, a lot of the arbitrators today are retired judges trying to make bank after years of having been relatively underpaid. Most of them would have been making more if they were in private practice, not all of them. This is one of the grounds that you can get your case dismissed, or that the case that's been brought up against you can be dismissed if there's an arbitration. That's something to look out for in contracts. As I said earlier, it's almost always put in there to make litigation by the party with shallower pockets less attractive. So when you see that in a prospective business deal, you need to ask yourself whether you can avoid it, whether you can get the arbitration clause taken out or softened. There are ways to do that. I'm not going to give legal advice. You know that none of this is legal advice, right? This is for entertainment purposes. Okay, educational, fine. But come on, you're entertained. You know what I'm saying? That is one of the grounds for dismissing a lawsuit. And believe me, there can be many, many complications. Did the arbitration agreement contemplate all the issues that arose among the parties? What if there's something that was a different deal? What if there was something that involved another party who is not subject to the arbitration agreement? It can get hairy. Where should the arbitration take place? We do find ways to complicate things. There may be motion to dismiss. And while the motion to dismiss is pending, in most of the busier courts where I practice, for example, the case goes on while the motion is pending. So you might 3-6 months or more after you have been litigating, giving evidence, going through your underwear drawer, ruining relationships with people by having them subpoenaed and asked to testify in your favor or against their boss or whatever the case may be. If a judge finally gets around to deciding that the case should never have been filed in the first place, for all practical purposes, there's nothing anybody can do about it. That's ridiculous. And it's ridiculous, especially because very few of these motions really should take that long to decide. But they do. I'm just trying to tell you what to expect if you get there. I hope you've appreciated our little talk today. Next lesson, we'll talk about answering the complaint.